7:30, and I am the chairman, Eric Spahn. I have member Mario Carnevale. I have member Elaine Baker, associate member Jack Kelly, and excellent administrative support from Martha Taylor, who is the town planner, and Christine Dupree. With us tonight, from time to time, is town council. We have Brian Winter with us. So with that, we'll open the meeting and go to the first hearing.
Okay, public hearing. AL Prime Energy Consultant at 23 Central Street. Applicant is requesting a reversal of the building commissioner's denial of the applicant's building permit application to raise the existing site improvements and construct a new retail motor fuel gas station with convenience store that includes a coffee shop tenant with drive-through window operations on the property located at 23 Central Street, Newbury Byfield. Assessors map R20-028.
All right, I'd like to come forward.
Good evening, Chair, members of the board. My name is Gordon Glass. I'm an associate attorney with Johnson & Bornstein LLC. We're a law firm situated at 12 Chestnut Street in Andover, Massachusetts. And I'm here tonight representing AL Prime Energy Consultant, Inc. as they appeal the building commissioner's denial of its building permit application. So I'm sure everyone's quite familiar with this project at this point. But with the board's permission, I do think it would be helpful this evening to just start with a brief procedural rundown of how this got to be here. So initially, AL Prime submitted two applications to the planning board. One application was for approval of site plan review, and the other application was for a special permit. In March of this year, the planning board denied both of those applications, both of which concern the project that was just mentioned, the proposed raising of a single-family home at 23 Central Street, which is situated in the commercial highway zoning district, and the replacement of that home with a gas station, a convenience store, and a coffee shop tenant with a drive-through window. The coffee shop tenant and the convenience store and the gas station required a special permit under the bylaw, but the convenience store was permitted as of right in the commercial highway district. As a result of the planning board's denials, AL Prime appealed both denials to the land court, at which point some preliminary procedural issues came up, and it was determined, and Massachusetts law is a little convoluted on this point and not particularly well settled, but it was determined that the land court had immediate review authority and jurisdiction to look at the denial of the special permit, but that this board was actually the appropriate venue to appeal the denial of site plan review approval. So, following what appeared to be the correct process, AL Prime applied to the building commissioner for a building permit for the project. In July of this year, the building commissioner denied that building permit, citing solely to the planning board's two decisions as the rationale for denying that building permit, which is how we got here tonight. So it appears that this board, under law, has the authority to make its own independent review of the project to see whether the project warrants site plan review approval, and in which case the board could overturn the building commissioner's decision on that particular portion. The special permit issue is going to be litigated in land court either way. I don't want to take up too much of everybody's time. I think it's not best to start these things with flood case law. I do think it's important to note that the Supreme Judicial Court has looked into site plan review, and their opinion on it is that site plan review is a creature that exists to facilitate the regulation and not prohibition of uses. Stated differently, it's there to protect the public interest under the imposition of reasonable terms and conditions. I think that's why we're here tonight, is AL Prime feels that the planning board's denial was premised on unreasonable terms and conditions. AL Prime went through back and forth with the planning board and its peer review consultants for quite a while, until it satisfied all of the peer review consultants, at which point the planning board still denied site plan review approval from AL Prime's perspective for some unreasonable reasons, such as an unsubstantiated fear for water pollution where the stormwater management plan complied with all relevant standards, and a preference that the gasoline pumps be moved to the back of the property away from Central Street, which was determined to be infeasible for several reasons. So hopefully we can all get out of here at a reasonable time tonight. I'm here to answer any questions I can to the best of my ability. And thanks for the board's time and consideration.
Thank you. So,
Mr. Chairman, if it's the board's will or wish, I'm happy to maybe provide a little context or an introduction if you think now is an appropriate time, or maybe later on after you've asked your own questions.
well,
But I'm here at your disposal, so please
Okay.
feel free to use me.
thank you. I think for the, at least speaking for myself and not for the rest of the board, but the question is of jurisdiction and of procedure and who in the town, per the bylaws, has the right to review and provide reviews. And that would be the, I think, in short, the question before us. Understanding what has been presented to the planning board, their review, their decisions, your rebuttal, and understanding all those facts, that I think the decision or the understanding of who has authority comes first. And so with that, I'd ask you to maybe provide some overview.
Sure. And I'll try to be succinct as I can, but as council pointed out, as I agree, this is a murky, kind of odd posture in any event, because what you have here is an administrative appeal from your building official, which isn't uncommon. That's something zoning boards do by statute. What makes this uncommon a little bit is that the administrative appeal is premised on the decision that another elected board engineer made that ended up as part of the building permit application and is now before you. So before we talk about the sort of planning board element and their decision, I just want to peel that back. What you have in front of you is an administrative appeal from a building official. So the same standard applies in this case as would apply in any case where you're hearing an administrative appeal. So it takes a supermajority of the board to reverse that decision, and the applicant bears the burden of demonstrating to you that there was error, factual or some erroneous legal conclusion that would justify tipping that official. Now, the statute also allows you to kind of stand in that official's shoes, and if you, by 3 out of 3 members, decide that there was some sort of error below, then you can modify the decision, reverse the decision. You have some more broad powers, some more discretion there. So that's the standard that applies here. They have the burden to prove that there was error. And if you find that there wasn't, or there wasn't a sufficient showing on the burden, you can decide it on those grounds. Or you can dive deeper and decide, get in a little bit into the facts, or however you want to proceed on it. Now, where the planning board's decision comes in is you're reviewing their decision not as the planning board. They're the site plan approval authority, not this board. So you're here hearing an appeal. So you have to decide not whether or not, if you were the planning board, would you have granted it, but is there anything that the applicant has demonstrated to show that there's some sort of reversible error in that decision? Did they make a conclusion of fact that's just not supported on the record before you? Have you heard evidence that there's some fact that the planning board just got wrong? Did they make an erroneous conclusion of law? Is that apparent on the record? Has the applicant carried their burden to show that the planning board just missed something? So it's really a confined scope in that regard. So I don't want to sort of tempt the board into doing a deeper dive than it needs to in order to sort of assume the role of the site plan or the site plan review authority. I don't think you need to go that far. And I'm saying this without prejudice to however the applicant wants to make its case. So if they want to present, a brand new hearing and present all the facts, they're entitled to present their case however they see fit. But your role is a little bit more circumscribed than that. So I'll sum it up with 2 questions that I would ask you to answer and to vote on at the end of this process. One is, has the applicant carried its burden to show that they were entitled to a building permit? Did your building official get it wrong? So in order to be entitled to a building permit, you need to show compliance with zoning. Do they have a special permit? Do they have site plan approval? So you know the answers to those questions. So did the building official get it wrong? Question number 2 is, you can't touch the special permit that's before the court right now. So with respect only to the site plan, as the applicant carried its burden to show that there was anything erroneous about the planning board's process, fact-finding, or conclusions that would justify you correcting some sort of error in that proceeding. So just one note on the case law, and as counsel pointed out, and again, as I agree, it's a little bit murky in this regard, but this is an administrative review process that courts have said an applicant has to exhaust before the court can review it. So what this process is really, and we have, I think, one case, we do one or two, but very few cases on this, and it's a Westwood case, Windstar Farm, or Wildstar Farm, I think, that said this is an opportunity internally for the town to correct an error or to get another bite at the apple before a court spends its resources reviewing it. So that's the kind of thing you want to look for. Is there something erroneous? Is there an error, apparent on the record? So if you find that the applicant has approved it or otherwise shown or on the record that there is one, you can stop that. As you know, the planning board had extensive hearings, a very lengthy fact-finding, a 14-page decision with extensive findings in that regard. So you don't need to become the planning board in order to conclude this hearing. So I hope that covers it.
Yes. Are there any questions? Jack, any questions? No? I guess so. With that understanding and background, is the applicant looking to present a case of errors beyond the memo and the memo that you provided us?
I think we would rely on that numbered list and that letter that I provided to the board. And again, just on the general principle that this is supposed to be about reasonable regulation of use, not about prohibition. Special permit decision is there to prohibit a use. I'm not suggesting that site plan review can't result in a denial, but that denial has to be based on some reasonable conditions that the applicant could actually comply with. And where those conditions suggested by the planning board are not fleshed out, such as an unsubstantiated water quality concern, or just infeasible, like moving of the gasoline pumps, those just aren't reasonable conditions an applicant can comply with.
You're referring to the letter dated September 16th?
Correct.
Thank you.
In terms of the planning board's decision? Is that what you're referring to?
The one he just
Oh,
cited,
yes.
the numbered list.
Yes. Well, I will say that typically the ZBA has been careful not to overstep its bounds in terms of other boards and committees in town for the work that they're responsible to do, which happens a fair amount. Usually questioning from the public where they are bringing up a concern, which we need to then guide them that it is another board or committee's responsibility in which to do that. The ZBA is, in my opinion, not looking to take on or take over the work of other boards of which they should do. That being said, I guess I'm just a little bit lost in terms of the understanding what you wrote here of how to qualify that in terms of your argument and presentation for the facts which you would find erroneous. I mean, you've presented them in the letter. Do you have precedent or other documentation in which to back up your stance?
So as you can tell, there are no other representatives of the applicant here this evening. I don't think it's applicant's intention to as noted by council, to mount a full new hearing on this issue. I think for the most part, applicant would just rely on the written submissions to the board, including that packet that I submitted along with the letter dated September 16th of documents that were before the planning board and the building commissioner.
board have any questions on the letter dated September 16th in terms of the presentation of reason for denial is incorrect for the following reasons, for which there are 22 items noted.
Well, I can tell you, I reviewed pages and pages and hours of reading, and I have to agree with the board's decision based on the special regulations and based on their knowledge of the town and the town zoning laws. So I agree with the planning board and building commissioner.
Elaine, do you have any
I agree with the building
questions?
commissioner. No.
Jack?
I didn't think, I read them also, I didn't see any of them that specifically found the first hurdle that the building inspector made any errors. I think there were a couple places where they argued with the planning board, but I'm not sure that that's ruled grounds to overrule it, so I'm on board.
I would say if, in terms of the written record that's before us, in order to do, if one was to do justice, you would have to then rehear, and that is the point that I think that the ZBA is not in a position to rehear the case of site plan review, which is specifically for the planning board. We do have that authority for the 40B, but it is a rare occasion, and so the standard in the town is for the planning board to review. With that said, and without significant argument for the determination of error, I think it's clear where we stand in terms of this, your administrative appeal. Is there any more discussion amongst the board?
I'm good.
I was just gonna note that it is a public hearing, so if you want.
Right. So, in terms of opening up the hearing to the public, as I had just stated, or hopefully may have stated, that this is not a discussion for or against, or an argument of too much traffic, too little traffic, I like it, I don't like it. This is, would open it up if someone had a question on the context for which the administrative appeal is being made and the process that is here before us and what we're actually discussing.
Jack Rybicki, 37 Larkin Road. Is the document that he submitted proposing 22 errors in the planning board's methodology, will that be a public document that we would be able to review to see what they're alleging the shortcomings of the planning board was or were? Or is this...
Any document submitted to us is for public record.
Very good. Thank you.
Anybody else? Yes, ma'am.
Kathy Sperling, 10 Parker River Drive. I'm not going to read my whole speech since I think you've already made your decision. But I really want to reiterate two things. One, the planning board decision, which is put out on the March 17th, 2021 memo, which you have read, is extremely extensive and really addresses everything that the community and the planning board laid out when they were seeking approval for the special permit and the site plan. The case is currently in land court. Some of the documents that are provided in the land court say that the reason the planning board found against the site plan was from some anecdotes from the community. I do take offense to that, since there was a lot of community input, a lot of thinking that went into it, and a lot of comment. The other thing is, I just wanted to bring up the lack of transparency of Prime regarding some of the documents that they've been providing, including the fact that they were going to widen the road, not on the side of the project, but on the opposite side, but yet they had no permit to do that. and they speak about the lighting in the March 21st document. The lighting is one thing for the site and the project, but the lighting is also about the cars and the trucks going through. So the documents are there, and I appreciate you reading it, but it's important to read all the effort that has really gone into this, and the fact that the community is really behind everything, and that LA Prime is now part of this community. They're coming in to work within our community, and we would expect that there would be transparency, and if there hasn't been any to date, I don't expect any in the future. Thank you.
Okay. Is there anybody else that would like to speak for or against, or have a comment? All right, close the public part of the hearing.
I make a motion
Sure.
to, make a motion to uphold the building commissioner and planning board denials of a special permit and site plan located at 23 Central Street in accordance with Chapter 97 Code and Town of Newbury, zoning 97-3G.
Second.
All those in favor?
Aye.
Aye. Have your decision?
Thank you.
Yes, thank you. Thank you everyone for attending.
Would it be the board's will to instruct council to work with staff to prepare a decision consistent
Anybody that reads the documents that are on.
You know, as you know from the other proceedings, I'll ask you to review it and adopt it as your written decision. So we'll have findings, obviously it'll be consistent with your decision. But we'll bump on the road or just some sort of fictitious process. They had the right to present, their case in the way they wanted and for you to conduct a hearing. But I don't think there was any surprise or any pretext here that we're going back to court. And that the likelihood of success at this hearing was very, very low. So this was so that they could just get back in front of the judge.
Thank you. That's how I understood it. I just wanted to make sure I was aware. Thank you.
You understand, I didn't really want to go there and say, well, this isn't the back, or anything to that effect. Maybe it isn't, I suppose, could have reached it down their decision. And I'm here to assist you with that. I'm sure you know this, but I'm not here to advocate for the planning board. So I was part of that, certainly, but I'm not here to say, God, you got to back down. I worked hard with them. This is a real hearing, so I wanted to treat it that way.
Right, there's a little more technical substance of what was in front of us as opposed to just reading,
Set of plans.
a set of plans and a bylaw and a review process. And I'm sure that after we've gone through the 40B process that we fully well conduct a hearing if somehow we needed to, or if another 40B came along. But as I had said, it's in the rights of who has the responsibility to do what.
And it's just so you understand, it's what we call a de novo hearing before the court. So we're going to do this all over again at a trial, all of it. And so whatever happened here in terms of the minutes, what the minutes will reflect and what documents were submitted, goes out the window. We get to do it all over from scratch.
Has there ever been a case where someone if we didn't agree with the building inspector's decision because we felt the planning board was erroneous, then you're basically just overturning the planning board's decision as opposed to sending it back to planning board and say, try harder.
Right. It's a very strange situation. So I could only foresee that under different circumstances. So here you had a very deliberative, thoughtful process before the planning board, but let's say it wasn't. And let's say it was a one-night hearing and they issued a very quick decision and they got something wrong. Well, this would be your chance to say, actually, this section doesn't say that, it says this. And so, maybe, there should have been something else here. So this would have been an opportunity, or could have been an opportunity to correct something like that. But when it comes down to, this is, sort of competing facts. Who do you believe? Who analyzed this and reached a conclusion based on, credibility of different, competing facts? That's not the kind of thing you really want to do a deep dive into here. And so when there's more of a sort of adjudicative process, that's harder for this board to touch. But if there had been something just plainly wrong, I think you probably could have gone there. And the one case that I was reading before coming here, and that I mentioned, that was one of those kind of situations where there was a formula in the bylaw, and the court actually, got an appeal from the ZBA, and then sent it back to the ZBA and said, I don't think you considered that formula the right way. I don't understand how you supported that conclusion. Do it again. And so the court made the ZBA kind of go through that process and say, no, we think the planning board and the building inspector actually got this right, and here's why. Because it required a little interpretation of the bylaw. So that could be one of those situations. But here it's, the bylaw says what it says. The board interpreter applied it, merged it with facts, and reached a conclusion. So that's much more of a deferential kind of situation.
Great, thank you. It's always.
And when's your next meeting? Make
Be
sure
the
I have this
third-
ready for you.
Third Thursday of the
I think it's
month,
October
21st, I think.
21st, okay.
so
Check.
unless we change it here in the meeting, it's always the third Thursday of the month at 7:30.
That's what messed me up last week. The third Thursday came early this month, and I was devastated.
Yeah, sometimes when the first falls on a Thursday, then it seems like it's a lot quicker than it should be. Okay, so do a motion to close?
Motion to close the meeting?
Second.
Favor?
Aye.
All right.